This video is an introduction to secondary sources for the Intellectual Property Legal Research course at Boston College Law School. To understand secondary sources, you need to first know what primary sources are. In law, primary sources are the statements of the law itself as created by governmental actors. In American law, these can take the form of cases, statutes or ordinances, regulations, or a constitution or charter. This primary law can be binding on or merely persuasive to a decision maker. Secondary sources are things written about the law. They are never binding. They have different levels of persuasiveness and serve a number of very useful purposes in legal research. Most lawyers, most of the time, begin their research with a secondary source. There are a number of reasons for this. First, secondary sources are generally easier to read and understand than primary sources, and there's a number of reasons for that. Very few judges or legislators were selected for their writing skills. Beyond that, cases only deal with the particular aspect of the case in controversy that is being decided at that time. Sometimes a decision might list all the elements of a tort before discussing in detail the particulars of the element that a decision rests on, but there's no requirement that they do so. Statutes, on the other hand, are sometimes purposefully drafted to be vague as part of the compromise process by which the legislators are able to get a particular piece of legislation enacted. Next, secondary sources tend to be well organized. Unlike judges writing a decision, secondary source authors are free to begin their discussion wherever they think makes the most sense, providing background and a logical progression of all the major points. They often have tables of contents or indexes that can help a researcher find specific discussions within them and then help explain the structure of the law as a whole. The next great thing about secondary sources is that they contain citations to primary sources. Legal authors don't write about the law without providing the reader references to actual sources of law that the author used to formulate his or her opinions. This allows the reader to decide for his or herself if the author of the secondary source correctly interpreted the law being explained. And finally, secondary sources lead you not just to lots of authorities, they lead you to the best authorities, including leading cases. While it's easy to do a word search and find every case that uses your search term, a secondary source will let you know which ones you should be reading first. It sort of takes the place of your first-year legal writing professor, who suggested which cases you should read first to get you started in the right direction in analyzing a particular legal issue. There are a variety of different types of secondary sources, which include treatises, periodicals, and specialty sources. Let's take a very brief look at each one of these. Treatises are books that deal formally and systematically with a particular subject. They are usually written by an expert in the field and can be one or more volumes. These have the potential to be considered highly persuasive and may be cited in persuasive legal writing as support for a particular interpretation of primary law. Legal treatises, like other types of books, are found in library catalogs. More and more treatises are available as ebooks through the major legal research platforms. You can link to many of the major IP research treatises through the Intellectual Property Subscription Databases Research Guide or through the Boston College Library's catalog. Periodicals are collections of articles that come out periodically, such as once a week or twice a year. There are four major types of legal periodicals: law reviews, bar journals, legal newspapers, and legal newsletters. Most American law reviews are published at law schools with student editorial boards and are the most likely to be used in persuasive writing. These can be useful when dealing with newer cases and statutes or cutting-edge issues. Bar journals and legal newspapers tend to be more practice-oriented and have practice pointers for people actively engaged in legal practice. Periodical articles on point can be found through full-text searching or by using periodical indexes, and there's a separate video on finding law review articles using indexes. There are a variety of specialty secondary sources in law. Some of the general specialty sources that can be useful in any kind of legal research are legal encyclopedias, like American Jurisprudence Second, called AmJur, and Corpus Juris Secundum, CJS, which contain short articles on different legal topics arranged in alphabetical order. Another is American Law Reports, which contains articles called annotations that discuss specific legal topics that were inspired by an individual case which made some change to the established law in that area. ALR has its own indexes and is searchable on Lexis and Westlaw. These tend not to be highly persuasive authority, but very useful as research tools. Another specialty source is something that used to be called a loose leaf service, but is now called a topical service. Most of these services are hybrids containing primary law on a topic, as well as commentaries, news, and finding aids. One major service published by Bloomberg BNA is United States Patents Quarterly. U.S.P.Q covers all IP law, not just patents. U.S.P.Q is available on the Bloomberg Law platform now in the IP practice centers. Another legal publisher, Commerce Clearinghouse, has a number of IP topical services, including the Copyright Law Reporter, the Trademark Law Guide, and the Guide to Computer Law. Link to them through the Intellectual Property Subscription Database's research guide at lawguides.bc.edu/IP. These are available on the Wolters Kluwer Cheetah platform. Set up a personal account on Cheetah to gain access to even more features such as email delivery of newsletters.